Good morning. This is the morning motion session. First on the list is the matter of Pavel versus Crazy Paws Animal Hospital, case number JKB 3959. I've reviewed the parties' filings, and if there are no initial matters, I believe it's defendant's motion. I'll hear from you first.
Good morning, Your Honor. May it please the court, my name is Nikki Pladziewicz, and I represent the defendant, Crazy Paws Animal Hospital. Before I begin, would you like to hear a brief summary of the facts?
No, counsel. I have a few questions, but we can get to those in the course of your argument, so you may proceed.
I would like to begin by stating that the essential function of the job position is standing in the operating room to supervise vet techs in a live operational setting. The Code of Federal Regulations provides evidence that the courts may consider to determine whether a function is essential.
So I'm sorry, can you back up and tell me just a little bit more about the big picture kind of basis for your motion?
Yes, my apologies, Your Honor. The defendant respectfully requests that this court grant summary judgment in favor of the defendant because the plaintiff is not a qualified individual within the meaning of the ADA, even if she could prove a prima facie case of employment discrimination. Crazy Paws Animal Hospital had legitimate, non-discriminatory reasons for its employment decision.
Thank you.
So turning back to the essential function, the courts may consider an employer's business judgment along with written job descriptions and consequences of not performing. In the job description, it outlines that the vet tech manager's responsibility is to supervise vet techs in a live operational setting.
But counsel, doesn't it not quite say that? Doesn't it say that it has to review vet techs and supervise and manage and do budgeting, and which may include being kind of physically in the OR? It seems like there's all these other things, and then it just may be necessary to be in the OR.
Yes, this is correct, Your Honor. However, the consequences of non-performance would be very detrimental to Crazy Paws Animal Hospital. The former vet tech, Mr. Joseph Washington, had caught an employee dazing off and not paying attention while he was in the operating room. If Ms. Pavel was not expected to supervise vet techs in this manner, then employees such as this would slip under the radar, and the consequences may include that the patient could suffer injury or serious death, would suffer from death, or which would result in potential Crazy Paws lawsuits.
So the idea is that even though the job description doesn't definitely say she has to be kind of physically standing in the OR, you're saying if the consequences are so bad, the court can kind of look to that instead.
Correct. I would also like to add that Ms. Pavel should have reason to know that standing is included, as Mr. Washington was her former manager, and that was the manner in which he would observe her while she was being observed. Additionally, the Hill v. Walker case concluded that employees cannot carve out an essential function and deem it non-essential. Here, Ms. Pavel cannot simply just say that standing in the operating room is not an essential function of the job and can't just say all these other responsibilities are essential.
So I recognize that line. Is Hill an 8th Circuit decision?
Yes, it is, Your Honor.
So I recognize that line, and that makes sense that an employee can't necessarily just say, that's not what I want the job to do. Why isn't this a marginal function? I mean, again, there's 8 or 9 different things listed in the job description. It seems like this is a pretty kind of broad administrative manager job. So why isn't this just a small marginal piece of the overall pie?
Well, Ms. Pavel and Mr. Washington both included in their depositions that supervision in the OR is an important part of the position. It's an effective way of viewing administration of anesthesia and observing vet techs under pressure. If she was not expected to observe vet techs in this manner, there would be no way for her to effectively review them in this manner.
And whose burden is it to establish that she's a qualified individual or to show the essential function?
The plaintiff has the burden to establish a prima facie case of employment discrimination.
So before we move on, counsel, my final question is, can't she, am I correct in that she can stand for 30 or so minutes?
Yes, she can, Your Honor. However,
So sorry, let me ask my question. Why can't she just go in a lot, right? So I understand there's this concerned about some of the longer surgeries she can't watch. Why can't she just watch more often for a short amount of time?
Your Honor, I agree that she could come in and she could observe shorter surgeries. However, the longer surgeries that Mr. Washington himself would supervise incorporated more difficult surgeries, and he would to ensure that that techs were being attentive and were able to adapt to emergency situations that would occur in a longer operation. I would also like to direct your attention again to the consequences of non-performance. Actually, I would like to direct your attention to her medical restriction. The ADA does not require an employer to allow an employee to perform a function that's medically forbidden. Crazy Paws is not allowed to require Ms. Pavel to stand longer than that 30-minute period. As I had mentioned before, some of the operations will last longer than 30 minutes. Even if Ms. Pavel can establish a prima facie case of employment discrimination, Crazy Paws Animal Hospital had legitimate non-discriminatory reasons for its hiring decision. In Hill versus St. Louis University, it states that the ADA does not prohibit employment decisions based on poor job performance, erroneous evaluations, personal conflicts between employees, or even unsound business practices. Here, Crazy Paws is allowed to consider Ms. Pavel's poor job performance as she demonstrated she was unorganized by failing to upload x-rays before a pre-op consult.
Counsel, what about, we characterize this as poor job performance, but what about the overwhelming evidence of the record that she was requested all the time, received 9 out of 10, all these ratings? Why isn't this kind of a convenient after the fact highlighting of just one or two small things on, frankly, what seems like an overall stellar record?
Yes, I would agree she does have a stellar record, but this case also says that we can consider additional things, not just her job performance, but they can also consider personal conflicts between employees. So I believe, so her poor job performance, in addition to the personal conflicts between employees, as she has had a formal complaint against her due to the way she spoke to a former secretary, Crazy Paws Animal Hospital may consider both in their employment decision.
And then my last question, it seems like there's some argument that she was given some different reasons here, and that why isn't that enough evidence to go to a jury and let a jury kind of work that out, whether that's, sufficient to show pretext?
I'm sorry, Your Honor,
Sure, I saw some evidence in the record suggesting that she was given different reasons, like it was, oh, you weren't organized, but then there were some personnel issues, like you just mentioned. So I guess I'm expecting to hear from plaintiff's counsel that is perhaps something they think should go to the jury to sort that out on whether that's pretext or not. So I guess, were those reasons shifting? And if they were, is that enough to show that your reasons were not legitimate? And I know your time is up, but you can go ahead and answer my question and then conclude.
Thank you. I believe, yes, that Crazy Paws, in fact, did have multiple reasons for not hiring her, but they were not discriminatory. One of the main reasons was that Ms. Jude Mahoney was a better candidate than Ms. Pavel. They both had similar qualifications in education, experience, and training. However, Jude Mahoney seemed more approachable when the hiring committee had approached staff. I'm sorry. May I conclude, Your Honor?
Sure.
The defendant respectfully requests that this court grant summary judgment in favor of the defendant. The plaintiff cannot establish a prima facie case of employment discrimination because she is not a qualified individual within the meaning of the ADA. Further, even if the plaintiff can establish a prima facie case of employment discrimination, Crazy Paws Animal Hospital was not discriminatory in its hiring process. Thank you, Your Honor.
Thank you, counsel. Go ahead.
Good morning, Your Honor.
Good morning, counsel.
My name is Mitchell Scott Wertheimer. I am counsel for the plaintiff, Ms. Annie Pavel. and we are requesting a denial of motion of summary judgment. If I may, I'd like to draw you towards the essential functions aspect of the job and why we believe Ms. Pavel was a qualified individual. It's stipulated in the joint stipulation of facts that she was qualified based on her education, based on her level of experience, and what is at issue essentially is whether or not she can perform a particular aspect of the job that the defendant claims is an essential function. Essential functions defined by employer's judgment. It's defined by written job description. Specifically, the job description of vet tech manager included some wording that was ambiguous. Bless you. Included some wording that was ambiguous at best. The sticking point is whether or not Ms. Pavel can stand in the OR, which she cannot for a prolonged period of time. The defendant claims that this is an essential function, and we disagree. The job description included the word may include some live observation. And it just doesn't reach the threshold of what one might consider essential, like going to work, if, for example, if you are a housekeeper and you are required to clean the floors, vacuuming is something that's essential. Standing in the OR is not essential, and based on the facts, based on the testimony from the previous manager, it was noted that it was a method in which he went about his job to oversee and to evaluate the vet techs.
But doesn't the CFR instruct the court to look at exactly what the past incumbent did?
Absolutely, it does. And it also looks to, it does look what the incumbent did, but this is like, I would call this a preference. So there's multiple ways one can observe. They can observe in a live operating setting, which she's able to do for a short period of time. She's not able to do it to the degree the former manager was able to do it. But again, there are countless other ways she can observe, and it's written on the record that there's countless other ways she can observe. She can observe in, non-operational settings, and I don't have the exact numbers, but I can tell you that these operational live settings was not the majority of time that these vet techs were working. There's other aspects, there's non-live operation.
But on that issue of time, and I know I asked your sister about this, but isn't it true that in the circuit or in general, is the time really matter? Meaning, can't something still be essential even if it's just a small amount of time?
It can if it reaches a certain threshold. And again, I would argue that this just doesn't reach that threshold of essential. We can go back again to employer's judgment, Moritz v. Frontier, Alexander v. Northland Inn, both looked at what was a fundamental aspect of the job. And if something didn't meet the threshold of fundamental, then it just wasn't an essential function. I think, in this job in particular, fundamental would be observing the vet techs. That's fundamental. The way in which the observation takes place is just a matter of personal preference. It's not a fundamental, essential function of this particular job. I would also point you to the testimony by Barbara Rea, the vet tech or the vet physician. She wrote a letter to Mr. Washington stating that she's going to miss the way he miss him, sitting at the desk observing vet techs, and she actually mentioned that she's going to miss seeing him with his feet propped up. And so I think if you look at this as a realistic picture of what the vet tech manager does, you can see that she obviously was under the opinion that this was such a immobile, sedentary job that in her mind, when she visualized the former vet tech manager, it was sitting at a desk, feet up, going through paperwork. It said nothing of live observation, which even further cements the fact that the live observation is not essential. It's not fundamental.
So my last question on that point is, what about counsel's argument that she's focusing on about the consequences? That, even if this is a small thing, maybe I get it, she's doing all these other things. If she's not watching these live observations for a long time and observing some of these vet techs, there could be serious consequences.
Sure, that is possible, and I would submit that there might have been an instance where that did take place. But we're not saying that Ms. Pavel can't do a live observational viewing. She can, and I would look to the the instance that my sister brings up. Did they time Mr. Washington? How long before the vet tech fell asleep? I just don't think that comes into play here. I think that
In
she's
terms
able.
of that being just happenstance that he may
Right.
have caught that one time.
There could have been a whole host of other reasons why this particular vet tech fell asleep. I don't think that Mrs. Pavel's inability to stand for longer than 30 minutes is going to affect her ability to mitigate that issue. Secondly, Your Honor, I'd like to bring you to the pretext aspect. So during the hiring process, Miss Pavel, excuse me, was I would say the victim of unfair hiring practices. She received different treatment, not preferential treatment, actually treatment different that is to her detriment. During the process, she made it to a second round of interviews with another individual, and she was subjected to an informal, off-the-record gathering of employees to share their opinions about, how she would be a good fit, how she would work. The issue there, obviously, Your Honor, is that this was not company policy, and it was not written in their employee handbook. Testimony and the evidence, in deposition shows that other employees agreed it's not company policy. This set her at a disadvantage. The other individual who was supposedly subjected to the same scrutiny wasn't. They were not a former employee.
But counsel, I guess I get that seems unfair, unfortunate, but I guess kind of who cares, right? Does the law say that they can't do that? I can see if you were here telling me they flipped a coin or something kind of way outside the bounds of fairness. Getting more information in kind of a funky manner, does the law really say that supports evidence of discriminatory animus?
Sure. I mean, previous rulings do support that differential treatment is a basis for pretext. Young v. Warner Jenkinson. That is a different case because they were discussing absenteeism and they were mischaracterizing it for a particular employee. But I would call Your Honor's attention to the fact that the policy was breached, and so that the breach of policy is the basis for pretext. It's the company was not following its procedure for an individual person for other reasons.
And from that, a jury can infer that they didn't follow that procedure because they wanted to not hire her.
I believe so, Your Honor. I do. I would also direct you to the communication and confusion after the fact. Ms. Pavel was an employee for 10 years, a stellar employee, received beautiful reviews. She was told that she was unorganized, and that's why she wasn't hired. And never in the decade that she was an employee, of Crazy Paws did she ever have that feedback. And her former manager, Mr. Washington, also testified that it was confusing. The reasons she was given were, erroneous, and he was also upset about that. And previous case law does support that, this miscommunication could prove pretext.
Okay. I see your time is up, counsel.
Yes. And if I can conclude, I would say that there are many genuine disputes of fact in this case, and I do believe that will require Your Honor to reject the motion for summary judgment.
Thank you, counsel. The court will take the matter under advisement and issue a written decision.